Hi everyone, this is Kirsten Davis in Gulfport, Florida for today's webinar on Legal Communication Scholarship. I hope you all can hear me. It's a beautiful day here in Florida today. Here is a little picture of me with my son. I'm your moderator for the day. This is my son in the picture, and this was one of his art days at school recently. So this is one of the most recent pictures of us here in Florida. Hopefully you can all hear me out there. If you can, it would be great for you to just type a little hello in your question and answer box. I know some of you already know how to do that. And while you're doing that, let me see if there's a hello. Thank you very much. I see the hellos coming in. Hello to all of you. Very helpful. Hello from Virginia. I see you. I see you there. Thank you. At least I know that you can hear me. Just to give you a little sense of your viewer screen, if you're brand new to this, here is the viewer window. It's on the left-hand side, and the control panel is on the right. And if you want to close that control panel at all, you can do that by hitting that little arrow key there, and it'll kind of make this happen. It'll make it close, and then you can hit it again to make that open back up if you want to move that off your screen. Just like that. If you're having any audio trouble at all, right there is where you can deal with your audio setup, turn up the volume, turn down the volume. Below that is one of the most important places for you. I see that you found that already. That's your question box. Anytime you have a question for me or for any of our presenters, go ahead and type that question in the question box, and I can answer it for you, or one of our presenters will answer it for you. Also, your control panel will auto-hide itself after 10 minutes if that little check mark there is checked. If you don't want it to auto-hide, just click on View and unclick that little check mark. So that'll stop it from opening and closing itself. So that's what you should be seeing in your screen. So just to make sure everybody's Q&A box is working and to get a little bit of participation going, I would love it if you would tell me what the topic of your summer writing project is, if you have one. Since we're going to be talking about writing and scholarship today, it would be great to know if you have any projects that you're pursuing right now. So I'll wait a second to see if anyone's out there. Thank you. Someone notes that Casey is really growing. Thank you. Yes, he is. He is growing. So Tanya's going to be writing on tribal court practice this summer. Thank you, Tanya, for letting us know about that. Oh, wait, here comes some more. We've got Jason writing on disability and higher education. Even one of our presenters has chimed in with what he's going to be writing on, and I lost track of it. Let's see. We have someone writing on the Convention of Rights on persons with disabilities. I've already told you about that one. And let's see what else here. Someone on the use of evidence in administrative proceedings, someone else writing on learning styles in the ADA. Wonderful. So I can see a lot of you already have your plans going for summer. But if not, maybe today's seminar will give you some ideas about that. Okay, great. So just as a reminder, our webinars are now available for replay. Please do let your colleagues know that they are available. They're free to anyone in the government or in education who wants to take a look at those, and you can see on your screen how to get into that. So if you want to do a screen capture of that, that's great. Also know that you'll get an email from me after today that will let you know how to get those from our website. Okay, just a quick note about upcoming webinars. The schedule for fall is not ready, but we're going to take a break for the summer and we'll get started back in the fall. And the first one we're very excited about. As you know, the new Allwed manual is coming out, and the dean here at the law school and the author of the Allwed manual, Darby Dickerson, is going to be talking to us about the changes and the updates to the Allwed manual. And so that's going to happen in the fall, either in August or September. So keep an eye out for those changes. Okay. So let's see. So we're going to quickly get to today's topic because I know our attendees want to hear from our presenters rather than from me. So let me just quickly introduce our presenters to you. And our first presenter today is going to be Aida Alaka. I told her I'd have to practice her name a number of times, but I think I did okay. Aida is a professor at Washburn University School of Law in Topeka, Kansas, and she's been writing about the relationship between students' perception of feedback and the kinds of things we should be doing in the classroom. So she's doing a little bit of work on pedagogy, and she's going to be talking to you about that. David Cleveland is a professor at Nova Southeastern University School of Law here in Florida, but closer to the end of the peninsula in Fort Lauderdale, and he's going to be talking to you about his continuing project of looking at unreported and non-precedential opinions. And finally, my colleague Lance Long here at Stetson University College of Law is going to talk a little bit today about his project, which is an empirical study related to the use of language in court briefs and whether there's any relationship between the language and outcomes in those cases. So what I'm going to do now is give the screen to Aida, who is going to tell us a little bit about her work in the area of commenting. And Aida, in just a second here, I'm going to unmute you so everyone can hear you. Are you there, Aida?
I am here. Can everybody hear me?
I can hear you just fine.
Okay, great. All right. Hopefully you can all see my screen, which shows my topics for today. I'm going to be talking about two projects that I worked on in the last couple of years. The first is Phenomenology of Error in Legal Writing, and the second, which was an offshoot of that project, is The Grammar Wars Comes to Law School. First, let me thank you, Kirsten, for inviting me today.
Aida,
yes.
Can I stop you? I don't think we all can see your screen. So you probably need to click the little box that says show your screen. Can you find that there? There we go. We see you now. Great. Thank you. Go right ahead.
Okay. Super. Are you seeing my control panel too?
Aida, go on ahead. We can see fine now.
Okay. All right. Great. But anyway, thank you, and hello to the other presenters. I'll be talking about what I learned during these two studies. One was a qualitative research study, an interview study of law school students at the beginning of their second year of law school, and the second was a study I did on changes in teaching grammar and punctuation in the grammar schools and high schools, and changes in pedagogy that have been going on since the mid-1980s. So before I begin, I'm having a screen freeze. There we go. Before I begin, I'll talk about the two observations that triggered my studies. The first was my reading the report of a 2001 study of judges, lawyers, practitioners, about the writing skills that they saw exhibited in recent graduates as well as law students. And the second trigger was my observation in my classroom. The study showed that we teach as a whole what the bench and bar consider to be critical elements of good writing. The study also showed that notwithstanding the fact that we're teaching what we should be teaching from their point of view, that they've found significant writing skill errors. And when I talk about writing skills during this entire presentation, I'll be referring to basic skills or technical skills, and I'm focused really today on things such as grammar and punctuation rather than substance analysis. So that was the first thing, that although we're teaching what we should be, we are still seeing graduating lawyers who are exhibiting poor writing skills. The second observation, and this is of course something that we've all noted, is that students tend to repeat their technical writing errors from their drafts to their final projects and between semesters. And this was true in my class, although I commented on the basic skill errors. In fact, I was one of those people who made a lot of line edits and margin comments on basic skills as well as organization, substance, research analysis, the use of CREAC, etc. So I commented on the errors and I graded on punctuation and grammar issues. And so I was a bit surprised to see that, notwithstanding that they seemed to have every incentive to correct those kinds of errors, they weren't doing it. So I undertook a study. First of all, I did research so that I could just help myself improve as a teacher, and I learned that, of course, it's generally accepted that formative feedback, such as commenting on these papers, is key to teaching writing. Our group in legal writing has been very active in publishing articles both on the educational foundation of commenting and on the nuts and bolts of doing it effectively and efficiently. My review of the literature suggested that although there was nearly unanimous agreement that commenting is key to teaching writing in legal writing programs, there was some disagreement about how much feedback to give, how to give the feedback, and whether one should comment on basic skills. There's certainly agreement that we bleed over these papers and that this is one of the hardest aspects of our jobs. So what I found was, okay, that from the view of practitioners and judges, we're teaching what we should be. From a pedagogical point of view, we're doing what we should be, and yet we're seeing the continued repetition of basic skills. That led me to devise a study of students, and like I said, I ended up interviewing 10 students at the beginning of their second year. 3 of those students were students I had had as first years in my legal writing class, and then there were 2 each from other legal writing instructors, or 3. The other ones, Tanya Kowalski, Jeff Jackson, and Lynn Gehring. And if anybody is interested in the process or the methodology of that, I'm certainly happy to answer any questions about that. But what they told me changed my teaching. I found that these students were very, very forthright about what they did with the comments that we gave them, even when it made them look bad. They were very honest with me, and so I will share some of what I learned. There's too much for me to go into all of it, but I'll try to pick some of the highlights. I saw, for example, that students underestimated the importance of writing skills. They were generally self-confident about their writing skills. They made limited use of our comments, and they didn't use the feedback to improve themselves as writers. And I also learned that they may not know how to do so. So some of this may be self-evident, but I guess hearing it from the students certainly made me think about what it was I was doing in my classroom to address even what we think of as obvious issues. For example, students underestimating the importance of writing skills to law practice. I'm going to have a couple of dense screens here because I thought some of you might be interested in reading what I heard during my interviews, and so I've picked a couple of quotes. I found it important that they underestimate the writing skills, and like I said, I think it's a little bit obvious simply because the media doesn't portray lawyers as sitting in libraries or doing research and writing for hours and editing their work. So they think of this as being a profession where oral skills are important, but not so much the writing skills. By the time I interviewed them, however, they had figured it out. They had had summer jobs, and like the second student here said, you tell us that this is important, but we don't believe you. And now we learn it is important. So what does that mean for us? As a result of this particular lesson, I have been inviting successful upper-level students to share their sometimes humiliating experiences with the feedback that they have received once they've gotten some legal employment. And they have shared some of the write-ups they've received, and they talk about the importance of writing on the job. I've had some of their actual comments that they've received on their writing, which they've allowed me to share with my class. So that's one of the things that I've done. I reiterate how this is a profession of professional writers, and I repeat that throughout the year. But they don't tend to listen to it simply when we give them that message because they see us as interested. So I think it's important to have other people send the message that they will be professional writers. I'm also trying to have Washburn's orientation program changed so that we can have outsiders come in to talk about the importance of writing before they start our class. After they've finished our class, it's too late. They are no longer able to kind of adjust their thinking to approach our class the way they should be approaching our class from the get-go. So that, I think, is a significant issue, and if other people have figured out a way to send a message in a way that helps the students approach our class in a more effective way, I would love to hear it. Another issue that I found was that students were self-confident about their writing skills. And by the way, I should say at the outset that a study of 10 students does not lend itself to making gross overgeneralizations here. This is what I learned from these students, and what it means for you is really up to you, and it would be interesting to have this study replicated at some point. But what I found was that they're very contradictory. On the one hand, students said that they felt that they were shaky technically, but they thought they were good writers. They admitted to being to having grammatical issues, but not being terribly worried about it. I found that interesting and, of course, illogical that one can think that they are a good writer and yet have grammar and punctuation skill problems. What I found is that their past experiences contributed to this perception. One thing is that students were not penalized for grammar and punctuation errors in high school and college. Those kinds of errors may have been noted, but they received an A nevertheless. So they were really rewarded in some ways for not taking the time to work on grammar and punctuation errors. In many cases, this was not necessarily true across the board. So they developed kind of a laissez-faire attitude about their basic skills. So that was one thing. The other thing was that they did not necessarily have that many occasions where they submitted a draft, received feedback, and then resubmitted it. So they don't know how to use comments effectively. And the final, even if there were comments on basic skills on the comments that professors gave them, it was easy to look at the grade and just move on. So again, the comments about grammar and punctuation really didn't register for many of these students. The other thing is that students may have been influenced by the grammar wars and the punctuation wars. What I learned during my research is, and this may be something that some of you who are younger than I am may have known already, but I was surprised to find this out, and that is that since the mid-1980s, there has been great debate in the language arts community on whether grammar and punctuation should even be taught as separate subjects, or whether they should be taught simply within the context of reading and writing. And obviously it makes sense to contextualize grammar and punctuation, but there are a couple of problems. One is that research shows that students are doing less and less writing and reading in their grammar and high schools. Part of this is driven by the No Child Left Behind Act, and it's focused on standardized testing as assessments. The other is that it's, larger classroom sizes, and there are other factors that go into the fact that reading and writing is occurring less and less frequently in our nation's classrooms. So if the idea is that students are going to learn basic skills through reading and writing, and they're not doing it, it certainly begs the question of how these students are supposed to have learned it. I found the grammar wars to be important because it certainly told me that in many cases our students are not necessarily, quote, to blame for what we see. And I think it's very important to not get as frustrated. It helped me not get as frustrated when I see the repetition of errors. The other interesting thing is that students made limited use of instructor comments because they assumed that we are their editors. This was interesting to me because it was true of the student who had the least number of comments on basic skill errors in his paper, and the student who had the most number of comments on basic skill errors. Both students thought that we comment on everything, and if we don't comment on it, there's no error and it doesn't exist. They actually assume that that's our job. It's the professor's job to show me what I did wrong. It's my job to go back and correct it. If there's no mark on it, there's no problem. I had always told my students that I don't mark every error, but that wasn't apparently getting the message across. It is really very important for us to be really clear in what our approach to commenting is, whether we're commenting just as examples of more endemic errors, or whether we're really trying to be thorough. Because certainly the number of marks doesn't seem to influence the way students approached basic skill errors. And we need to make sure that they understand that we are not their editors, and that we comment in order to help them improve their writing. On a related note, the students also approached their revisions very mechanically. And I know that from the literature, part of the debate on whether we should be commenting on these kinds of basic skill errors revolves around the issue of whether we're doing their work for them. I found that we are, in some cases, at least for my students. If they saw that there was a problem, they made the correction. If they didn't, it wasn't an error. They did sit and just mechanically, as one student said, mindlessly made the changes. So they didn't take ownership of the right of their writing, of the output, the way that we would want them to take ownership. I've changed the way I assign my projects as a result. In the first semester and second semester, I've always had 2-issue projects, and now what I do is they only turn in their analysis of the first issue at the midterm, but not both issues. I give them assignments where they are required to analyze my comments and determine whether any patterns exist. Of course, I'm very clear that I'm only giving them examples of edits for wordiness, an example of improper comma usage, etc., so that they know that I am not catching, quote, every error. So the benefit of dividing my projects up now is beneficial for the students in more than one way. One is that it allows them more time to work on, to actually research and analyze the problem, and then work on communicating that in writing. So while they're researching the second issue, I can be grading their first issue, and they're not trying to cram so much into that midterm draft. which I think is very important in terms of their ability to learn the material that I'm trying to teach them. The other thing is that they cannot be mechanical. They need to be able to use my comments on their drafts to improve their writing on the second issue. So that's one of the things that I've done in my classroom, and I know that some of my colleagues have done the same. What are some of the solutions? The literature tells us that some of what we see is related to problems with transfer, and others have written about this, including my colleague Tanya Kowalski. It is not unusual for people who are entering new situations to demonstrate a loss of skills, so that, and this is true not just in legal writing but all writing, so that good writers will appear to lose skills when they are writing in a new context. Thus, it's not unusual to see a loss of skills at the beginning of first semester and also a loss of skills at the beginning of second semester. Part of that has to do with transfer. We need to, I think, make more opportunities for students to think about their learning. Part of that I do with what I now do with my comments, asking them to reflect on my comments, analyze my comments. But I also have designed projects at the beginning of second semester that ask them to identify goals for second semester to improve their writing. What problems do they have? What is legal writing? What do they need to work on? What concrete steps will they take to improve their writing? And then with the midterm brief, I ask them again to reassess their approach to the classroom. Did they in fact take those steps that they said that they were going to take at the beginning of the semester? So I've put more emphasis on their on making them active learners in my classroom. I think it's important to recognize that students may not have learned the material to begin with when it comes to grammar and punctuation. Thus, telling them to, read the Aspen Handbook on the rules on comma are only going to have limited effect. The more motivated students will actually do that, but one of the things that I found is that students tended to ignore directives like that in the margins. They did not, in fact, go to OWL or go to the handbook or use the resources that they were directed to. Even when they were expressly told, go to page 68, for example, they ignored that. Part of that is understandable. If they never learned the rules to begin with, it's like telling them to go to a German dictionary to learn German. So that's part of the problems. And then we need to address the problems head on. We certainly can't solve the problems alone. I think we need to get the message out to our colleagues, and certainly we've done that for all of you out there who have made the case successfully and are still making the case for writing across the curriculum. I think that what our students here at Washburn told me certainly adds a lot of depth and urgency to the writing across the curriculum movement. Finally, I want to just say that there's no need to throw the baby out with the bathwater. I still comment. I just do it more judiciously, and I try to be much more transparent in my commenting practices. I make fewer line edits than I did at the beginning. I make fewer margin comments that are directed at grammar and punctuation, and I ask students to come in during times that are not just office hours to work with me one-on-one, and the motivated students will take me up on that. So I learned a lot. There's only so much I can, afraid I've gone over, but if you have any questions, suggestions, or feedback, I'm certainly happy to hear it.
Aida, thank you. We did have one question that came in for you that I thought you might want to address now. Did your research tell you anything about either students' perceptions or things we can do about the differences across sections. So, for example, if you're switching sections at mid-year, do students comment on, or do you have thoughts about the differences between professors focusing on different grammar points or having a different understanding of correct grammar? Did that come up at all?
We have sometimes switched sections here, and we're going to be doing it again next year. Some of us will be switching sections. But the students that I interviewed had not switched sections. That had not been a year where we switched sections at all. So it didn't specifically come up. But what I do when I'm about to switch, I usually pass off to another professor. And what I do is I really put that in a positive light. I tell them, first of all, that there is nothing that I can say on their papers that is going to be the equivalent of what they will get when they get out into practice in terms of the feedback, in terms of the negativity of what they're going to get. I tell them that they are lucky to have more than one teacher because they'll be writing for more than one professor. I mean, for more than one audience once they get out of law school. And so it's a benefit to be writing for more than one instructor. When that is going to happen. I tell them that we focus on different things, but that doesn't mean that we value different things. I mean, that we don't value, for example, grammar and punctuation. And certainly within us here at Washburn, we don't all focus on grammar and punctuation to the same extent. We certainly focus on different things in our classrooms. But one thing I do is I point out that grammar and punctuation are substantive. They're not style. They're substantive. And so I bring in ambiguous contracts. I bring in constitutional provisions that have caused problems in the states. I bring in the $2 million commas. This makes the point that it doesn't really matter who's teaching you and who's reading your work. There is substance to these issues.
Thank you very much. So we're going to turn now to David Cleveland. David, I'm going to release the screen to you. I can hear you, I think, and you should be able to have control of the screen. So, David, we're ready when you are.
Wonderful. Thank you.
We can see your screen, David.
Okay. Excellent. Thank you. Thank you very much, Kirsten. Thank you for the opportunity, you and to Stetson, and thank you to everyone who has joined us at this webinar. I really appreciate being asked to speak on this panel, but I must admit my first impression was, is what I'm doing legal writing scholarship? Do you really want me on this panel? And my reason was I don't think of what I do as legal writing scholarship. I have several things on my scholarly agenda I'd like to get to that I think are legal writing scholarship that are very helpful related to what I do and what we do in terms of teaching students and thinking about their learning and their thinking and our processes. But this is not that. At least what I have spent the last 4 years doing is not that. I think it is doctrinal scholarship, and it is done by a legal writing professor. It does involve the process of writing, that is writing court opinions. It touches on some writing relating issues, and I've at least been able to change some of my classroom practices to include more substantive discussion of what I've learned about unpublished opinions. I think I probably should have tuned into the prior webinar that discussed what is legal writing scholarship, and I know there was an LWI conference panel that discussed this at some length. The reason why I was concerned about it mainly is I think what I have to say may be less inherently interesting or less inherently helpful to you than the kind of things that Aida's just presented to us. And so I suspect I'll have a difficult time following her, but I appreciate the opportunity to speak about this. I do think it's traditional doctrinal scholarship, so to the extent that people are interested in some of that done by a legal writing professor on a tangentially related issue to legal writing, I think I fit that well. I do have a classical scholarly agenda. That is, as I was writing the first article, I was immediately looking for additional spin-off articles that could come from it, and I think I built what is a logical progression of articles on this topic all of which have been traditional law review pieces, 2 of which I've been fortunate to have in peer-reviewed journals. I've presented them numerous times at general scholarship conferences, but also managed to present at least a few times these issues to legal writing faculty at the Rocky Mountain Legal Writing Conference most recently. And I do think there is some opportunity for us to think about what it is we're teaching our students in regard to common law and precedent and unpublished opinions. Which gets me, I guess, finally to the substance. My great white whale for the last 4.5 to 5 years has been this issue of unpublished opinions. The idea that some cases merely apply the law, they don't make any new law, and so they're less important. They can be relegated to a sort of out of sight, out of mind dustbin of the law, and that these unpublished opinions are either not citable or not precedent or both. The premise for this was that some cases make law. They make new law. They establish a new rule of law. But the rest of the cases, they just apply it to familiar circumstances and nothing new is gained. The idea is that if this is true, we can save some judicial time and energy and save the mass publication and lawyer costs of searching them if we just make them unpublished. The reason why this frustrated me was it comes out of my practice experience. I practiced in Michigan and in the Sixth Circuit, where the rule was essentially you could cite these with a copy and notice to the opposing party and a copy attached for the court. Working at the law firm that I did, a large law firm, we always cited one. Even though the rule said it was disfavored but permitted, we always cited one because it gave the court the notice that we were finding the most recent cases and that we had gone the extra mile. Which led me to my curiosity about how is this really possible? Can you really have a common law court issuing an opinion that isn't precedent or that isn't citable to it or shouldn't be cited to it? And then finally, that's led me sort of to my outrage. I was speaking with a fellow author in the field, Bill Reynolds at Maryland, who said, the more I think and write about this, the angrier I get. And I realized that was exactly my experience. The more I think about it, the angrier I get. The more I think this was inappropriate in the first place, and while I understand the pragmatic benefits, I just don't think it's ever been justified jurisprudentially. The crux of the problem is this, and this is part of what I presented at the Rocky Mountain Legal Writing Conference, is we teach students that the common law is made up of individual interpretations of the law. We teach them that a rule of law comes down, and additional decisions come later that interpret that and apply that law. They apply it to new facts, which expand or contract the scope of the law. Each new case gives sort of strength to that rule of law by saying it's been more recently applied. And even if the case is exactly similar, at least it tells us there's an additive benefit. That is, at least some of us, I think, tell our students rhetorically to say, this is a commonly applied principle, or this principle has been applied in a number of circumstances, and cite to those. But I think most cases are at least slightly different from a prior case, and to that extent, the court has expanded or contracted the law, however, greatly. To say that some of these cases aren't law or only apply the law doesn't really make any sense. And to make 84% of the court's decisions in this sort of secret, unpublished fashion, I think is crazy. And that's the number presently of the federal appellate circuits. They issue 84% of their decisions as unpublished. Every layperson I talk to finds this to be just outrageous. What it leaves is 16%. And so I can tell you this is 16% of something. 16% of something important. Does it matter that what I've given you is the rarer 16%, the more outstanding 16%, and the rest are the more common letters, the average, a lot of vowels and more common consonants? It doesn't really. You still don't get the full picture. And yet what would emerge if you had the full picture would be something very, very important. And so I think that's what we're missing. Another great analogy that I've heard is that the law is like a pointillist picture or like a graph with data points. We are missing just far too many points in that pointillist picture or data points on that graph to really get a sense of what the law is. What's worse and what my research has revealed is that this idea of issuing unpublished opinions was never justified. The 1973 Commission of the Federal Judicial Conference looked at the issue and said, well, we want to make these decisions unpublished, but if we do that, we better tell lawyers they can't cite them. So let's make them not citable. And someone raised the very legitimate question, well, if we make them not published and not citable, can we make them not precedential? And what the committee said was, we can't make them explicitly not precedential. To do so would be to enter a morass of jurisprudence that we would rather avoid. So instead, what we will do is rely on the correspondence between not being able to find and cite them and not being able to rely on them as precedent. It's completely a judicial out of sight, out of mind, hocus pocus kind of approach. It's never been jurisprudentially justified that you can take a common law decision and relegate it to not precedential status. I think that's contrary to how the common law works. I think it exceeds their Article III judicial power. The framers would never have understood an idea of a court without precedent. This was something that the Federalists thought was a strength of our system, and the Anti-Federalists thought was the downfall of having a central Supreme Court. But what they both agreed on was a common law court fashioned after the English model would involve precedent, and that our system did involve precedent. I also think it violates due process. The due process protection requires that something that was a due process protection to the people at the time of the framing can only be removed if a substitute protection is put in place. And here, I think the idea that a court would be bound by a previous decision of a higher court is just such a due process protection. I also think the practice violates equal protection in the sense that similarly situated parties, or in some cases even the same party, can come before the court in two occasions and get a different decision, one unpublished and one published. And this actually happened in the Dallas area. Their local rapid transit authority was sued for a slip and fall by a passenger, claimed qualified immunity. The Fifth Circuit held in an unpublished opinion that they did in fact have qualified immunity as a quasi-governmental agency. They dropped a great deal of their insurance for this reason, planned their operations around that idea, that holding. And if I were their lawyer, I think I would have told them they could be pretty secure. A decision of the Fifth Circuit, unlikely to be reviewed by the Supreme Court on this issue anytime soon. And yet within 2 years, in a published decision, the Fifth Circuit reversed itself without overruling the prior ruling or distinguishing it factually, just basically ignoring it. And that is a core equal protection violation. I also think it's contrary to what lawyers and lay people think of as justice. Lay people continue to be outraged by the concept when they hear of it. I was recently quoted in an ABA online journal, and many people chimed in, some of them clearly not lawyers, about how egregious the practice was of attempting to sort of hide these decisions. It's also contrary to the way lawyers think. The demand for these unpublished opinions has created a market where now they're published. They're literally physically published in paper form. And so my works on the topic have essentially been a progression of those points. In my first work, Overturning the Last Stone, I looked at a comprehensive history of publication, touching briefly on ancient Egypt and ancient Rome, but really starting in the 12th century with early common law. And what I found was that publication and precedent have always been intertwined, but it was not until the mid-1970s that any common law court ever said a decision it makes can be decided to be not precedent at the time it makes it. In early common law England, even if it wasn't physically published, a lawyer could stand before the bar and say, "My lord, you decided, this court decided in Stone v. Smythe 2 years ago X," and a court would have to take account of that. And we've had a period now, about 20-some years, where you couldn't even tell a court what it had done, and only in the last couple of years can you tell them, but it's still not binding on them. They feel free to ignore it. I looked at all of those constitutional infirmities I discussed and practical and pragmatic infirmities I discussed, and out of those came the second article I wrote, which was an examination of what the court has done on this issue. The Supreme Court has never accepted the premise that these are not precedent. They have never taken a case on it, though it comes before them on a cert petition a couple times a year on average. And several justices before the court were either authors of the rule or author of the recent rule allowing citation, or Justice Stevens, for example, has been in favor of abolishing this system since its inception, or like Scalia and Thomas would agree with my premise regarding the framers' opinions. And so it seems like this decision is ripe for review by the court. What I attempted to build onto that was the next article, Local Rules in the Wake, which looks at the fact that even though this new federal rule is in place, it hasn't resolved this conflict. Some cases, some circuits, federal circuits, give no guidance at all about what cases should be published. Others give only general guidance, and some give specific. Even on citation, which the rule addresses particularly, some go only to the extent of the new federal rule, and some open the door to all unpublished opinions. And regarding precedent, that's, I think, the most critical point and the least examined point, and yet there's still a difference. In at least 2 circuits, cases can be cited for their precedential value, even if they're unpublished. In 2 or 3 others, it's vague whether there can be precedent, but it's an open door. In 4 or so, it's explicitly not permitted. And so there exists still this circuit conflict, of a sense, that I think really harms the law. I'm working on 3 more articles regarding this now. One is out for publication that looks at a specific harm that's being caused. When a government official is sued for a violation of a civil right, they often plead qualified immunity. And what that says is, I didn't violate a clearly established rule of law. If an unpublished opinion really is what the federal courts say it is, a clearly established law that makes no new law, they should always be looking at these to determine whether something qualified immunity exists or not. And the fact is they don't. There's a significant split on that. The next work, my summer work, I didn't chime in when Kirsten asked, my summer work is 2 things. One is, I think, an essay on how central precedent is to the idea of justice. You know it when you're 5. Your 5-year-old will tell you that your 7-year-old got to have a new backpack last month and they should get one. Or your 14-year-old will tell you, well, when my older sister was 14, she got to stay out until this time. We just inherently know that precedent is important to justice. And then finally, even if anyone should ever listen to me and agree, the next question is, and I was asked to assist in filing a petition to the Supreme Court on this issue recently. And what kept me up at night as I was preparing that was, if I were to stand before the court, I know that some of the more pragmatic justices would ask me, okay, Mr. Cleveland, if we do what you ask, then what? And so I came up with a list of other practical solutions to the volume problem that don't involve the same jurisprudential deficiency that I see. And some of that is restructuring the circuit courts, additional circuits, additional judges, but some of it's far more radical, like using more Article I courts to decide things like Social Security and Medicare appeals and things of that nature. So the title Empire Quagmire refers to the fact that I've had some success in this field and building a reputation in it and getting lots of good articles out of it, but I do seem stuck addressing these problems that continue to bedevil me and anger me, and those of you who have seen more than one of my presentations realize I'm getting more sort of worked up about it as time goes by. And I think I would welcome your comments and questions regarding any portion of this, and even though I didn't address it much, in particular, the way I think that it affects our classrooms.
David, thank you very much. That is my question for you. Just briefly, and I see one of our folks have it here, is how do you bring some of this discussion of precedential and non-precedential opinions into the classroom? When do you do it? How do you do it? And how do you find time to do it would be one of my questions.
That's a great question, and one that I've done it 3 different ways in the past 3 years, and my presentation at Rocky Mountain was that I think there is a tiered approach. I mean, I think at a minimum, your students are going to come to you and say, I found this opinion, it seems to be different. They might not even know unpublished, but it seems to be different. Can I use it? I think you can just answer them straightforward, yes or no. You can tell them this is an unpublished opinion. The court thinks it to be of lesser value. You can cite it, but realize it's like citing a persuasive authority rather than a binding authority. You can take the next tier up, which I think is to engage them a little bit more and say, you should check the local rules on whether you can cite unpublished opinions. And when they locate it and follow it, you can have a brief discussion about why the local rule is the way it is. And this past year, because I couldn't help myself, I did a more full-blown discussion about what the court's trying to do with these unpublished opinions. I tried to be fair and not so biased in my presentation to them about it. What are the ills that the court's trying to cure? What problems does it cause for you as an advocate? Should you cite it or not cite it? And gave them strategies for using, for example, an unpublished opinion paired with a published opinion that establishes that rule. So what you're doing is citing the published opinion for the rule and the unpublished opinion for the application to fact. And I said, you know, that's weaker than 2 published opinions, but it's still of value. And I'd be happy to share my PowerPoint presentation from the Rocky Mountain Legal Writing Conference with anyone that wants it. It did include a handout which I think can be used 3 ways. It can either just be handed to them, it's a question and answer fact form with all the answers in it, or you could remove all the answers and give that to them as a question, just the blank questions, and use that as guided discussion, or you can give it to them as an assignment. It's like 10 or 12 questions that range from very straightforward and practical to this very theoretical, and just make them go out and answer it. And within seeing 2 or 3 law review articles, they will be able to answer, you know, these questions and have a better grasp of what these things are about.
Thank you. That was very helpful. And so we're going to leave David now, and we're going to move on. Hopefully, I'm going to change the screen to Lance Long, who is on the road, I think, in the middle of the country. Are you with me, Lance?
That is correct. I am actually calling not too far from Aida. I'm on I-70 just outside of Salina, Kansas, which goes to show what you can actually do with this webinar technology. I think it's wonderful. And so I'll just follow suit with what David said and just tell you that this is good that we did this in alphabetical order, because actually mine's probably the least significant pedagogically, I maybe, and if you're running out of time, you won't miss much, and I'll try to condense my presentation at any rate. In the rhetorical question I asked in my title page here is, does empirical analysis have a place in legal case? And of course, the answer, as we all know, is yes, because we all love to play around with things like correlation matrices. And we love to see values of statistics and chi-squared and all sorts of things. Furthermore, we love beautiful, detailed, complicated graphs that try to express our findings in comprehensible terms. And just based on this alone, of course, it has a place in legal writing scholarship. But beyond that, beyond the real reasons we do it, why should we, or why did I start using empirical analysis as the basis for my legal scholarship? What really intrigued me, and I was interested also that David actually gave a history of how he got into this. I'll give my brief history as well. It started with the 2006 AALS conference, which was based around, those of you who attended or remember it, it was all about empirical research in the law, empirical analysis in the law, and the marriage to a certain extent of the social sciences with law and the methodology of the social sciences with law. I was fascinated by the conference. That was the DC conference, as I recall. Shortly thereafter, I read the book Freakonomics by the Chicago economist John Levitt. I don't know if the attendees have read it or not. If you have, give a little comment to Kirsten Davis and say, yeah, I love Freakonomics, or what are you talking about? But at any rate, she can chime in and tell us what people are saying. But the book applies economic analysis to very mundane questions that arise in every aspect of life, and things that were, to me, quite interesting. His claim that crime rates went down primarily because of abortions increasing. Very controversial, but he had great statistics and great data showing that this may be the case. Finally, the thing that really narrowed it down for me, the whole idea of using statistics for law, was a statement from Richard Newman's writing text, and which I was using at the time, and I have it there in the presentation. And when he said that, I thought, well, that is really interesting. He's making a claim that intensifiers, such as obvious and clearly, actually are contrary to the purpose. After this little quote in his book, he gives a phrase with the intensifiers and a phrase without the intensifiers, and says, you know, which do you find more compelling? And the claim was that it's more compelling to not use the intensifiers, even though we all know that the point of using an intensifier is to emphasize the text that follows the intent. So I thought that, well, that is interesting. I wonder where he got the conclusion from. Or I would love to see if I could develop a study or determine in a evidential that this is actually so. And so by the way, I asked Richard about this, and he said, I don't know, I guess I just thought it up or pulled it out of my head. It seemed right, or maybe I heard it somewhere. Anyway, he was being somewhat humorous. I'm sure he had good reasons for doing this. But anyway, the point was, I thought, well, why don't I try to determine whether the rate of intensifier used in an appellate brief correlates with the rate of success on appeal. I mean, if this is so, could it actually make a difference whether these intensifiers were used? In other words, if it really does divert attention from the meaning and in fact signals to the judge maybe that the writer is uncertain and is trying to bolster their language by using this, would it have an effect on outcome? So I devised a study. Basically, I took a random selection of 400 state Supreme Court and federal appellate court cases, and I basically did a word search and found all the uses of 7 common intensifiers. I won't go into the details, but it was a statistically valid study. Everything was done by the book. And as I'm going to mention here a little bit, it wasn't that I have the ability to do this, and I might as well just say this now. If you're interested in doing empirical research, or if you've done it, you know that the statistical aspect can get quite technical. I do not have those abilities. I associated with a great statistician, William Christensen from Brigham Young University, on both this first project and a follow-up project. I couldn't do it otherwise. There are certain types of empirical analyses I would feel totally comfortable doing by myself, but these types I was not. Anyway, just let me talk briefly about my study results and then what I think this means for legal communication scholarship and maybe some other areas that people have done, just some ideas of what can be done with this. It was interesting. At first, when I analyzed all the intensifiers used in these 800 opinions and 400 cases, I thought, well, it was interesting because the result didn't initially support the common wisdom. In other words, by using intensifiers, you actually detract and lessen the significance of your message. My results were statistically relevant for appellants, and only when you consider it in light of the opinion intensifier rate. In other words, judges use intensifiers in opinions, and how they use intensifiers was essential to determining whether there was any association, statistically significant association. Here's what we found. Basically, an appellant's odds of prevailing were reduced by 63% for each intensifier per page if an opinion contained no intensifiers. In other words, if intensifiers and you use a lot of intensifiers, you're more likely to lose. Now, of course, I will say it right now, this is not necessarily a causal relationship to. And so, on the other hand, if an opinion uses many intensifiers in the opinion, then the odds of prevailing were increased by 257%. So this was an unexpected finding, and we were kind of startled by it because we thought, well, wow. At first, it seems that intensifier rate does actually work like Richard Newman, and by the way, all other legal writing texts, most of them contain similar caveats about using intensifiers. So basically what we kind of thought from this was the following. We thought that maybe attorneys and judges use intensifier-rich language simply to bolster an argument that they believe is weak, even though they know the common wisdom is to not do so. In other words, we throw our reason to the wind when we're trying to bolster a weak argument. This conclusion was supported by the fact that everyone uses more intensifiers when there is a dissent. Appellants use 66% more intensifiers. when there is a dissent, as opposed to 58% without a dissent. Appellees 72 versus 59. Majority opinions use or actually use 49% more when there is a dissent, and of course the dissenting opinions themselves use 1.29, 129% more opinions or intensifiers than other forms of the writing. So the important point about this is that when things become less clear, in other words, when you have a dissent, so maybe not everyone agrees with the decision, as things become less clear, actually we use more intensifiers, just the opposite of what we ought to do, because obviously and clearly means that there is no issue here. Instead, we use it exactly the opposite fashion. So this was the anomalous result, and we thought a follow-up study would be warranted. So we started collecting data on the Supreme Court, U.S. Supreme Court, and we did additional research on our already selected cases. And these were the questions that we were trying to answer. Are intensifiers the cause of the altered results, or are they an easily identified marker of poor usage and poor style generally? In other words, if people are ignoring the intensifier rules, are they ignoring the rules that Aida talked about with punctuation? Are they writing long sentences with nested modifiers? Are they having long paragraphs? Are they omitting topic or thesis sentences? Or is it that lawyers or just resort to intensifiers when they have a hard, and we can read that as a losing or lose argument? Or does it mean that you should write for your audience? In other words, if the judge uses a lot of intensifiers, then you want to write like the judge, and if the judge you should copy that style. Or is this just a fluke? Is it just a statistical anomaly? So we went ahead and did this last study, and it was an expanded study, and what we did was we used Fleisch-Kincaid readability studies to see if there's any correlation, and those of you who are familiar with these studies know that it basically tests the complexity of writing. And if you, depending on the scale you use, it grades it from a 18th grade level to a first grade level. And so we thought, well, this, and we also tested the same writing, Supreme Court writing, for passive voice. And we thought, well, we'll be able to detect maybe bad writing styles generally with these other things. Now, they correlate if poor readability, high use of passive voice, and high use of intensifiers all correlate, well, then maybe it is that intensifiers are a marker of poor language generally. So we did this study, and that's the study I'm writing and will finish this summer. And the conclusions were this. The intensifier use is associated with appellate outcomes. No question about it. It was reaffirmed in our expanded study in every court, both the U.S. Supreme Court level, state Supreme Court level, federal appellate court level. Intensifier use was associated with the appellate outcomes in a statistically significant manner. Of course, we don't claim it's a causal relationship. What we do believe is that attorneys and judges use intensifier-rich language when they believe they need to bolster their argument. In other words, that second thing, that is what apparently is happening. And the other finding was that at the Supreme Court level, and probably at most other levels too, we haven't completed the analysis completely, but readability, and by inference poor writing, probably does not affect outcome. In other words, the only statistically significant component of our research that we found so far was a relationship, an associational relationship between appellate outcomes and intensifier usage. You could write at a higher or a lower, more complex or less complex. You could throw more passive voice, less passive voice in, and it did not, in our study, statistically affect the outcome. Now that should be good news. David would like that judges aren't unconsciously or consciously swayed by poor writing so much that they would. But nevertheless, it is important to realize that there is a statistically significant association here, and in a larger sense, I think this is important because our students will want to know when we make claims, why, who says this? Why should we have the conclusion first? Why does that make the brief more readable? Long sentences and long paragraphs. Is there anything that really says this, or are you just pulling this out of a hat or making this up? And it extends far beyond my particular area of inquiry, which has to do with language patterns and language usage in appellate briefs and how that correlates with outcomes. There's many questions. A colleague I talked to from another school said he wanted to write about one of our other maybe which might seem to be an anecdotal statement that we always claim, which is it is better to use court opinions from surrounding jurisdictions. They're more persuasive than court opinions from faraway jurisdictions. Well, who says that's necessary? So is that really true? Can we show that? He wanted to design a study where he tracks briefs that use nearby persuasive opinions, maybe with briefs that use further away, and are they in fact more persuasive? Is that related to outcome? There's a lot of other things you can do. Many people have done other types of empirical work, and there's more being done. All these are the late 2000s, all these articles that I just mentioned right here. Got Issues, an empirical study about framing them, defining legal writing, empirical analysis of the legal memorandum, Judges on Briefing, a national survey by Brian Gardner. All these things discuss various aspects of how we write both the language and structure a legal memorandum and how it affects maybe a court or how it's perceived, and in some cases, is there any statistical significance? All sorts of different ways to approach this. Finally, the last article here by Lucerico is, I had to throw this in because he talks in this article, it's in Quinnipiac Law Review, that a readability study, which I just did one on the second part of it, how technocentrism can compromise research and legal determinations. Very good article, and you can't rely on readability or any of these statistical analyses completely as providing a definitive answer. Sometimes they may be of slightly more, maybe equal value to the anecdotal answer. But I do think it's important to make the effort to engage in this type of scholarly research and apply it to legal writing. I think, in essence, that's kind of what AIDA did, and I think I think that David's work is very applicable to legal communication scholarship, and I think this an empirical can be extremely helpful. I love doing it. There's other areas of the law, more doctrinal, to get to, but I got so sucked into this that I have to complete this, and I have a couple other things I need to get through to do this, to finish this line of turn my attention to other things. So that's what I'm doing, and I think it is a wonderful area of inquiry, and the thing I kind of want to leave you with is don't feel like because you don't have a statistics background that you can't do this. Much of it can be done without a statistics background, and to the extent you need one, there are people both in the legal writing community as well as in the university setting at large that can assist and co-author with this. So those are some of my thoughts. If you have any questions real quick, I know we're probably about out of time. I'd be happy to answer them. If we don't have time, Kirsten, that's fine as well.
Lance, thank you very much for that. And I didn't see any new questions pop up, so I'm going to say that most people have ended their lunch hour and are ready to end now. But I will say that all of these presenters have their papers available, as I understand it, either on SSRN or on their websites. And so if you want to check that out, you can, and I'm sure they'd be amenable to any questions that you have for them personally. Please be sure to join us again in the fall, and on your way out you will be getting a little survey that asks you for your input on what other topics we could be covering and how you enjoyed today's topic. So everyone, have a great end of the semester. Tanya says, see everybody at LWI at Marco Island this summer, and I will see you there too. Thank you so much, and have a great day, and thank you to our presenters who really went out of their way to share with us today. Thank you so much. Have a great day, everyone. Goodbye.